Equality and diversity in the workplace. Welcome to the Fall to Ireland video series designed to support tourism and hospitality businesses in meeting your employer obligations. My name is Caroline Reedy. I'm the Managing Director of the HR Suite. In this video guide, I will address equality and diversity in the workplace. The key topics that I will cover are an overview of key legislation pertaining to equality and diversity, a look at equality in the recruitment process as well as within the workplace as it pertains to equality and equal opportunities, policies and procedures relating to equality and diversity in the workplace, considerations around diversity in the workplace, and some key takeaways. Equality and diversity are so important in the workplace. Equality in the workplace involves ensuring that every individual has equal opportunities in all aspects of employment. Employers have an obligation to ensure that their employees have a safe place to work, and that includes a workplace free from discrimination. Employers with a reputation for a diverse and inclusive workplace will be more attractive not only to their customers, but also to potential employees. It is important to remember that it can take up to 20 years to build a reputation as an employer offering a safe place of work that promotes equality, but this reputation can be lost in minutes. In an environment where attracting and retaining staff is so important, it is essential that businesses create and maintain a diverse and equal workplace. When it comes to equality in the workplace, the key pieces of legislation we look at are the Employment Equality Acts. The Employment Equality Acts include the Employment Equality Act 1998, the Equality Act 2004, the Civil Law Miscellaneous Provisions Act 2011, and the Equality Miscellaneous Provisions Act 2015. The Act covers not only existing employment relationships, but also the termination of employment and even the treatment of a prospective or former employee. Crucially, it's important to note that there is no minimum length of service required in order to bring a claim under the Act. The Acts outline 9 grounds on which discrimination is outlawed. These are gender, civil status, family status, sexual orientation, religious belief, age, disability, race, colour, nationality, ethnic or national origins, and membership of the traveller community. The Acts state that discrimination regarding any of the 9 grounds shall be deemed to occur where a person is treated less favourably than another person is, has been, or would be in a comparable situation based on any of the 9 grounds. The Act also referred to 4 specific types of discrimination that are prohibited. These are direct discrimination, indirect discrimination, harassment, and victimization. Direct discrimination is when a worker is treated less favourably than another worker in the same situation or circumstances under any of the 9 grounds covered in the Acts. Indirect discrimination captures the most subtle and often institutionalised ways in which employees may be treated less favourably, but in a manner that is not necessarily obviously linked to their status. The Irish Human Rights and Equality Commission state that indirect discrimination happens where a worker or a group of workers or job applicants are treated less favourably as a result of requirements that might be difficult for them to satisfy. For example, if a job advertisement stated that applicants must be of a certain height, this may put women at a particular disadvantage. This rationale for this requirement must therefore be objectively justified. To objectively justify their actions, an employer must show that their actions were fair to do so in terms of achieving an important aim. For example, a chef who is part of a religion that believes beards can't be cut or shaven might claim that they are being discriminated against because of their religion when told they must be clean and shaven or wear a beard mask. However, this is objectively justified by reason of health and safety. Harassment, put simply, involves any unwanted conduct related to any of the discriminatory grounds. This unwanted conduct must have the purpose or effect of violating a person's dignity and creating an intimidating, hostile, degrading, humiliating, or an offensive environment for the person. Lastly, the Act also prohibits victimization. Victimization is essentially where a person is treated less favourably after they make a complaint in relation to equality, or where they're involved in a complaint in any way, for example, being used as a comparator. The Act prohibits any discrimination on any of the 9 grounds in terms of access to employment, meaning any arrangements the employer makes to decide who should be offered employment. This also includes practices used when advertising positions. So it is important to ensure you are careful in the wording of role profiles or job descriptions to ensure there is no suggestion or interpretation of an intention to discriminate. An example of this, in terms of the Equality Authority versus an airline, occurred in 2000. In this case, the airline placed an advert seeking a young and dynamic professional. The equality officer at the time held that the word young clearly indicated or might reasonably be understood as indicating an intention to exclude applicants who were not young. The same consideration around equality and ensuring no discrimination must also be given to interview questions. For example, in a case in 2007 involving a teacher versus a school, a claim arose after the claimant was unsuccessful in securing the role of principal. The successful applicant was younger, and at the interview, all candidates were asked the question, can you offer the selection committee a brief outline as to why you feel at this stage of your career you are the most suitable candidate for the position of principal? The employee claimed that this question implied she needed to justify her interest with regard to her age. This question was listed as one of the factors which led to the equality officer to uphold the age discrimination claim. Moving beyond recruitment and promotion, equality is relevant in all aspects of the employment lifecycle. This includes making reasonable accommodation for an employee with a disability. An example case in this regard is the case of a primary school versus a special needs assistant, which proceeded all the way to the High Court. In this case, the employee was tragically injured in an accident, leaving her wheelchair-bound. Following her partial recovery, she sought to return to work and was referred to an occupational health doctor by her employer. The doctor found the employee could not perform some of the tasks of an SNA, but could carry out some of the others, and she could be accommodated as a floating SNA. The principal of the school was reluctant to accommodate the employee in this way and asked the doctor to reassess her fitness for work. The doctor reported back that in light of the school's difficulties with accommodation, he was certifying the respondent as unfit for the SNA position. The school then terminated the employee's contract, and the Labour Court awarded the employee €40,000 in compensation, and the High Court dismissed the school's subsequent appeal, agreeing with the Labour Court that the school only assessed reasonable accommodation that would be required to allow the employee to return to full duties and failed to consider a return to adjusted duties. This case highlights the importance of considering all possibilities in making reasonable accommodations for employees with a disability. It is also important to consider that not all disabilities are visible, and disabilities can include physical, intellectual, learning, cognitive, emotional, or medical conditions. Case law has established that disabilities can include conditions such as depression, epilepsy, claustrophobia, alcoholism, ADHD, dyslexia, and more. Employers who act fairly and reasonably will generally avoid claims of this nature, but it is important to remain aware of them. Employers should look to develop a clear recruitment policy and accompanying documents such as approved job descriptions, adverts, application forms, lists of interview questions, and other recruitment documents. Doing so will put the necessary provisions in place to avoid claims of this nature. Employers should also consider all possibilities in making reasonable accommodations for employees with a disability. Make your employee feel confident that you're doing everything you can to ensure a safe place of work. Recently, we have seen an increase in age discrimination claims relating to retirement. Retirement is essentially the right of an employer to lawfully terminate an employee's contract upon reaching a certain age and has traditionally been used as a means of lawfully managing the exit of older workers from the workforce. While compulsory retirements are still permitted in Ireland, they must now be capable of being justified on a legitimate and objective basis. Otherwise, such compulsory retirements will be considered to constitute age discrimination. One of the most vital steps an employer needs to take when setting a compulsory retirement age is to communicate compulsory retirement ages to employees, ideally as an explicit term in their contract of employment. However, even if a retirement age is stated in the contract of employment, it must still be objectively justified by a legitimate aim, and the means of achieving that aim must be appropriately and necessary in order to avoid a claim of age discrimination. The courts have put out some examples within the law to justify a mandatory retirement age. These include intergenerational fairness, meaning allowing a younger worker to progress; health and safety, which is generally more relevant in more safety critical occupations; personal and professional dignity, which relates to avoiding capability issues with older employees; or succession planning. In a recent WRC case, an employee of a food and beverage company was awarded €40,000 after being forced to retire at 65. In this case, the employee's request to work beyond 65 was denied in order to allow younger workers to progress. The adjudicator found that while this was a legitimate aim for their retirement, their actions were unnecessary and disproportionate due to the delay in processing the complainant's grievance regarding working past the retirement age, and because the organisation did not take an individual and supportive approach to retirement and instead took a one-size-fits-all approach. The adjudicator therefore found that the employee received discriminatory treatment on age grounds. This case highlights the importance of taking requests to work beyond retirement on an individual basis to avoid cases of age discrimination. Another important aspect of the Employment Equality Acts is the concept of vicarious liability. Under this Act, essentially this means that anything done by the person in the course of their employment shall be treated as done also by that person's employer, whether it was done by the employer's knowledge or not. Essentially, the employer is responsible for the actions of their employees. This concept was most recently seen in a case against a Dublin hotel, where the property was ordered to pay €12,500 to an employee for racially discriminating against an employee when a manager called him a racially discriminatory term repeated on his first shift at the hotel. Employers have an obligation to provide a safe place of work for their employees, and this includes being fairly and equally treated at work. Employers can take steps to ensure their workplace is a safe one by providing training to employees and managers, and by updating and regularly circulating relevant policies. Taking these steps will ensure you have a defence to claims of vicarious liability. There are a number of important policies relating to equality and diversity that are recommended for you to have in place in your business to support your efforts to comply with the legislation and protect your business against potential claims. These include an equal opportunities policy, a dignity and respect policy, a diversity and inclusion policy. An equal opportunities policy should confirm that an organisation is an equal opportunities employer and does not discriminate on any of the 9 grounds under the Employment Equality Act. The aim of such a policy is to encourage harmony and respect amongst individuals to promote good work practices. It should include a statement recognising what an organisation should do to encourage and support equality and good practices under the policy. A dignity and respect policy can also be referred to as a bullying and harassment policy. This policy should outline the definitions of bullying, harassment, and sexual harassment, and should outline the options available to employees if they feel they have been subject to any behaviour that falls under those definitions. The options available to them should be in compliance with the Code of Practice for employers and employees on the prevention and resolution of bullying at work and the Code of Practice on sexual harassment and harassment at work. The policy should also outline employees' obligations in respect to dignity at work. Although there is no requirement to have a written diversity and inclusion policy, it's a good idea to produce one to demonstrate that the organisation takes its legal and moral obligations towards diversity and inclusion as an employer seriously. The policy should include information on diversity and inclusion, and it should also showcase the business commitment in respect to fostering an environment of inclusion for employees. While the terms diversity and inclusion are often used interchangeably, they are different. Employers should recognise the difference and acknowledge the need to have both within their organisation. According to the Harvard Business Publishing, diversity is anything that sets one individual apart from another, including the full spectrum of human demographic differences, as well as different ideas, backgrounds, and opinion that people bring. It is the existence of differences in a particular setting, i.e., race, gender, religion, and so on. Organisations should aim to hire a diverse team of people that's reflective of the society in which it exists and serves. According to the CIPD, inclusion is defined where people's differences are valued and used to enable everyone to thrive at work. An inclusive working environment is one in which everyone feels they belong and are welcome without having to change their behaviour to fit in. It's a workplace where everybody's contribution matters, no matter their background, culture, or personal circumstances. People of all backgrounds and personalities are treated the same, and that allows all employees to prosper. Essentially, diversity is what makes people different, and inclusion is how we bring them together. An inclusive workplace has fair policies and practices in place and enables a diverse range of people to work together effectively. We won't go further into detail here, as we will look specifically at bullying in video 7 and harassment in video 8 of this HR series. A diverse and inclusive workplace has many benefits. These include its attraction to employees, as potential employees are more attracted to companies that represent a diverse and inclusive workforce. People want to work for employers with good employment practices. They also want to feel valued at work. Retention is also aided in a diverse and inclusive workplace, as employees who feel valued and included are more likely to stay with the organisation. A diverse and inclusive workplace can benefit from a better reputation with potential employees, customers, and other stakeholders, such as investors. A diverse and inclusive workplace also promotes a positive culture and a sense of well-being. Making a move towards a more diverse and inclusive workplace should involve the organisation looking at its current practices, identifying where barriers lie, and taking action accordingly. Organisations should make a plan to review their employment policies and practices, taking a more inclusive approach to these policies. It is also important to introduce clear, equality, and anti-bullying and harassment policies, and to implement and reissue these policies as required. Organisations should also review their current training schedule or strategy to ensure that they include relevant training around dignity and respect and equality. Training should be provided for both staff and managers to encourage professional, respectful behaviour and leading by example. Other supporting resources, such as an employee assistance programme, can also be rolled out alongside training of this nature. Finally, organisations should review what communication in their organisation currently looks like and should take steps to ensure appropriate communication methods are being used. Promoting a culture of positive behaviours on an ongoing basis and ensuring that those in senior roles lead by example and are actively communicating appropriately with employees is also a positive practice. To summarise, it's important to remember the need to recognise, protect and promote equality, diversity and inclusion in the workplace, particularly in the current climate where attraction and retention is a high priority. Now let's consider some key actions arising out of today's session. Organisations should conduct a review of their current recruitment processes to ensure practices are free from discrimination in all areas, including but not limited to job advertisements, interview questions, and scoring. Organisations should ensure that fair and appropriate scoring, note-taking, and record-keeping is included in their practices. Management teams should be aware of their requirements in terms of reasonable accommodation and should recognise that not all disabilities are visible. Management staff should also be aware of the approach to take if an employee discloses their disability and should be equipped with appropriate training if they do not have currently knowledge in this area. If your business has a compulsory retirement age, consider if this is objectively justified for each position with a legitimate aim and whether this means of achieving that aim is appropriate and necessary. Businesses are advised to take an individualised approach to requests to work beyond retirement. Employers should look at introducing policies such as equal opportunities, a dignity and respect policy, and a diversity and inclusion policy. A review should also take place of current policies to ensure an inclusive approach is taken. Finally, it is recommended that organisations should review their current training schedule or strategy to ensure the relevant training around dignity and respect, equality and communication is included for all staff. Further information and guidance on how to fulfil your employer obligations is available in the other video resources in this suite.